Good afternoon and welcome to this month's Badger Forum. I'm Andy Perdue, Chairman of your Badger Club Program Committee, and I will serve as your moderator today. Before we begin, let me remind you to please turn off your cell phones. 6 weeks ago, the U.S. Supreme Court decision in Burwell versus Hobby Lobby allows closely held for-profit companies to be exempt from law its owners religiously object to if there's a less restrictive means of furthering the law's interest. How this landmark decision by the U.S. Supreme Court might affect us is the subject of today's Columbia Basin Badger Forum. To discuss this, we are fortunate to have two expert speakers with us. Leah Ruttman is Policy Counsel for the ACLU of Washington and Seattle, where she focuses on the impact of religion on healthcare and religious secular health systems affiliations. Prior to joining the ACLU, she was an associate in an international law firm working on commercial litigation. She earned her bachelor's degree from McGill University and her law degree from Columbia University. Joseph Backholm has served as the director of the Family Policy Institute of Washington since 2007. His job is to train leaders to be more effective public policy advocates, promote marriage, life, religious freedom, and parental rights in the legislature, and help to hold elected officials accountable for decisions they make. He earned his bachelor's degree from the University of Washington and his law degree from Seattle University. Leah, let's start with you.
My name is Leah Ruttman, and I'm Policy Counsel for the ACLU of Washington. The ACLU is a strong proponent of the fundamental right to religious freedom. We've supported that right throughout Washington State and throughout the country. However, while we think religious freedom is absolutely essential and something we will protect on and over again, we don't believe anyone's individual religious freedom gives individuals the right to discriminate, the right to harm other people. We live in a very diverse society with many different people who hold very different religious values and beliefs. So while religion is a fundamental right, we have to make sure when exercising that right, we don't impose our beliefs on others, and our beliefs don't harm others who happen to hold different beliefs. Unfortunately, in Hobby Lobby, the court seemed to sanction just that. At issue in Hobby Lobby was a section of the Affordable Care Act, the contraceptive rule. This rule requires health plans to cover all FDA-approved forms of contraception, a birth control, without a copay. There was two reasons that this rule was enacted. The first was that studies had shown that women were paying far more, significantly more than men, for preventative health care, and there were cost barriers making it impossible for them to even obtain this care. This rule was trying to address that, to give women equal access to health care as men. The second purpose of the rule was to ensure that women and families, women and their significant others, decided when and if to have children. The people drafting the contraceptive rule realized that this was a decision between families, a private decision, not something a boss should determine. They also realized that women's ability to access and succeed equally in society was fundamentally correlated with their ability to control their reproductive lives. So the Affordable Care Act, the contraceptive rule, was enacted to try to give women some equality. So then what happened in Hobby Lobby? In Hobby Lobby, the court ruled that under federal law, for-profit, closely held corporations need not comply with the contraceptive rule if they objected to it on religious grounds. The court determined that these corporations did not have to provide a health care benefit that only women need, a benefit that helps women to participate equally in society. Essentially, in Hobby Lobby, the court sanctioned discrimination against women, and it put the personal opinion of employers above the law and above the health needs of women and the practice of medicine generally. So let's be clear here. You may have heard on the news or from others that this ruling was really limited, that it only related to 4 specific types of contraceptive care, and it only applies to closely held corporations. But if you actually read the language of the decision, which I do not expect anyone in this room to do, but as lawyers we have to, in the decision, the language and the logic of the court would apply to all contraceptives. And it also, when we look at closely held corporations, these aren't these tiny corporations that only impact a few people. These are huge, huge company. Mars Incorporated, which is a family-owned candy giant, takes in $33 billion in revenues. That's a closely owned corporation. Cargill, which has $136 billion, closely held corporation. Coke companies, Coke Industries could be considered a closely held corporation. This will impact many women and many families. And this really doesn't even just impact these people, because based on Hobby Lobby, employers may now feel emboldened to contest providing health plans that cover anything that might be religiously objected to. They could object to blood transfusions. They could object to mental health services, to in vitro fertilization. Access to health care is essential to every single one of you in this room and to every member of our society, both for equal participation, but for survival as well. And your employer's religious beliefs, your boss's beliefs, should not hurt your ability or your loved one's ability to get the health care you need. This even goes beyond health care. Basically, in Hobby Lobby, the highest court in the country ruled that it is acceptable for a corporation's religious beliefs to take away benefits guaranteed by a basic law. What does this mean? What other laws will employers try to get out of, claiming that they're objecting on religious beliefs? Equal pay is required by law, and I think most people in this room and most people generally do not believe that your boss's religious beliefs should be allowed to impact your paycheck. But in the past, there have been cases where religious entities have argued that they should be able to compensate married women less than married men on the religious basis that men are supposed to be the heads of the households. Will employers now try to make these claims? Will the courts accept or reject them? In the past, courts have always rejected these claims, finding that the principle of non-discrimination meant that regardless of religion, institutions had to provide equal pay. With Hobby Lobby, this could potentially change. Thankfully, the rights of Washingtonians are protected. In Washington state, we have really strong laws, and Hobby Lobby was decided under a federal law that does not impact the states. In Hobby Lobby, we have strong laws that say contraceptive coverage is required by an employer's health plan if the plan covers other prescription drugs. We also have really strong anti-discrimination laws that mean people are protected and will continue to be protected. Religious freedom does not include the right to discriminate in the commercial marketplace, and your boss should not decide whether you have access to health care. A free and diverse society requires everyone in this room and in society, including corporations with religiously observant owners, to comply with laws intended to advance public health and the general well-being of society. Thank you.
Good afternoon, Joseph Backholm. Pleasure to be with you guys and discuss this today. I'm going to start by clarifying kind of where this lawsuit came from. The Affordable Care Act, euphemistically known as Obamacare, required 20 different forms of contraception to be provided. Hobby Lobby provided 16 of those, willingly, happily, to their employees. 4 of them they were concerned about on religious grounds because they believe that those drugs cause abortions, and that is something that is not consistent with their faith. So they said, as to these 4 specific kinds of contraception, we don't want to pay for them. And what the Supreme Court said in Hobby Lobby was that the Religious Freedom Restoration Act protects the right of those individuals not to have to do something as employers that they could not be forced to do as individuals. Now I want to tell the story of where RFRA, the Religious Freedom Restoration Act, came from. And it goes back to 1963 in the case of Sherbert v. Werner. And in that case, there was a Seventh-day Adventist woman who had applied for unemployment benefits because she had been dismissed for her job for her refusal to work on Saturday. And obviously a fundamental tenet of Seventh-day Adventism. And she had been denied those benefits. But the Supreme Court, after the case, said that no, because this is a fundamental tenet of her belief, the government cannot punish her as to eligibility for those benefits for exercising her belief. Therefore, you cannot deprive somebody of a benefit that everybody has, that everybody else would have access to, that you would not have access to if you follow your religious convictions. And out of that came the Sherbert test. And what it basically said is that it established strict scrutiny for the government's ability to interfere with someone's fundamental right to the free exercise of religion. And what it says, if the individual has a sincere religious belief, whether the government's action, you have to decide if it is a sincere belief and if the government's action burdens that belief. And if both of those things are true, if it's a sincere belief, if the belief is burdened by the government's action, then the government has to prove two things. One, that it has a substantial interest in whatever step it is taking to burden that belief, and that the step that it is taking is narrowly tailored to accomplish that purpose, which means there can't be another reason, there can't be another way to accomplish the state's objective. And so that is the highest standard that the Supreme Court has ever applied to the protection of fundamental rights, free speech rights, free exercise of religion rights. And so that was the Sherbert test. And it was reinforced again in 1972 in the Wisconsin versus Yoder case, where compulsory school laws were found to not apply to the Amish because it is a fundamental tenet of their belief and has been for centuries that their schooling stops in 8th grade. And the Supreme Court recognized that there was not a compelling interest to tell these specific people that they had to send their kids to a specific school in violation of their beliefs. And so they upheld that standard. Now, this started to be eroded in the 1980s, and there were two specific cases in which that happened. One was in 1998. It was the Ling versus Northwest Indian Cemetery Protective Association. And a native tribe, their property was going to be developed by the U.S. Forest Service, and they were going to run over sacred land to them that had been sacred for generations. And they wanted to protest the development of their sacred land, and the government said, no, you can't, because basically, and I'll read here, make sure I get this right, they ruled that it was not an adequate legal burden because the government was not coercing or punishing them for their beliefs. It's saying, we're not coercing you or punishing you specifically. This just happens to affect you, but too bad because we're not targeting you. A second case in 1990, Unemployment Division versus Smith. This had to do, it's an unemployment case again, but with Native Americans who were fired from their job because they had been tested positive for mescaline, which is a substance in peyote, which is an illegal substance, but for centuries has been used by Native Americans in religious practice. So they had been fired for their job because they had that substance, and as a result, they had been denied unemployment benefits. And what they came to court and said is, hey, just like the Seventh-day Adventist woman 30 years before, we shouldn't be denied a benefit for doing something that has been a fundamental tenet of our religious belief for centuries. And the court, in this case, as opposed to the Seventh-day Adventist case, they said, no, you're not protected. And they lowered the standard. They departed from the Sherbert standard, and they said that, because doing something, they said that you could be fired in that case from your job. And so they lowered the standard in 1993. And what happened nationally was Congress looked at this and said, wait, we value religious freedom. And they've departed from the Sherbert standard, and what they said is because this law is generally applicable, it's forbidden for everybody. They're the only ones who want to use it, but because it's forbidden for everybody, then the specific impact it has on Native Americans, we're just going to ignore that. That's what the Supreme Court said, and said we will deny you your benefits anyway. And Congress said that is unacceptable because we believe that religious freedom is a fundamental tenet. The right of conscience is a fundamental tenet of what it means to be an American. So, in 1993, they responded with the Religious Freedom Restoration Act. They restored the Sherbert standard from 1963 that the Supreme Court had done away with in 1990. And what they said is, no, if we the government, this is Congress speaking, if we are going to take away your religious freedom, we have to prove that there's a substantial burden, that there's a good reason, a compelling reason to do so, and that the action that we are taking is the only possible way of accomplishing that. That's what the court said in the Hobby Lobby case is you have failed to meet that burden because, and what's obvious to all of us, is there are lots of ways to get contraception to people other than forcing somebody who doesn't want to buy it for you. There are other ways, including the government buying it, which is one of the things that the Supreme Court said. Now, that's the Sherbert test, and that's what we, as advocates for religious freedom, believe. Now, another alternative is being proposed, and I'm actually going to read the last sentence of Leah's statement there, of the alternative of what's being proposed to the Sherbert test. And she said, a free and pluralistic society requires everyone, including corporations and religiously observant owners, to comply with laws intended to advance public health care and the general public interest. So that standard that is being proposed today is, as long as we intend to advance public health and the general public interest, you are required to obey that law. Now think about the implications of that, because advocates of internment during World War II, advocates of segregation, advocates of book burning, advocates of every form of censorship, all intend the public good. But that's not the way America was structured. The reason we created the Bill of Rights is to limit what the federal government can do, with the full knowledge that what government does with good intentions is take away the rights of individuals. They came from England, where there was a state church, and the people who required church attendance at a specific church had good intentions. And the reason we have a Bill of Rights, which limits the jurisdiction of government and protects the individuals, is because we know people will do things that are harmful to the individual while still having good intentions. And so, what does that mean? The government is limited by what they can do to protect people from offensive speech, because the First Amendment guarantees the individuals the right of free expression. There are limits to what the government can do to keep us safe, because the Fourth Amendment prohibits the government from searching people without a warrant. We theoretically could make the world much safer if the cops could go into any home or any car and stop and frisk you because you might have a gun and you might hurt someone. There are limits to what we can do to keep people safe from bad guys, because we require a trial by jury, and we require people to be able to face their accuser in court. We have this presupposition that we would rather let guilty people go free than rather let an innocent person be convicted, because we are making choices based on our presupposition that an individual's rights are really important, and that people often do and will, if we allow them to, do bad things, all the while having very good intentions. So the debate I think we're having here is it the Sherbert test or is it the good intentions test? And I'm going to quote C.S. Lewis here, and I think this is helpful in this discussion. Of all tyrannies, a tyranny sincerely exercised for the good of its victims may be the most oppressive. It would be better to live under robber barons than under omnipotent moral busybodies. The robber baron's cruelty may sometimes sleep. His cupidity may at some point be satiated. But those who torment us for our own good will torment us without end, for they do so with the approval of their own conscience. The Supreme Court did not do anything unprecedented or historic in this case. They simply reaffirmed the standard that has existed in the United States since the First Amendment was written, and since it was reinforced through the Sherbert test in 1962. And I'll finish my opening remarks by saying, and I think this is a fundamental point in all of this, the fact that you have a right to something does not carry with it a corresponding obligation for me to provide it to you. You have the right to move about freely. I do not have an obligation to buy you a car. You have the right to free speech. I do not have an obligation to buy you a website, put your letter in the editor, or even listen to what you have to say. You have the right to keep and bear arms, but you cannot force your boss to buy you a gun. The debate here is not about whether somebody has the right to purchase contraception. That is granted. The debate here is whether I, as an individual, because I have the right to purchase contraception, I can force somebody who objects to it as a matter of sincere religious belief, if I can force them, or the state, with the police powers, with a gun in hand, can force them to buy it for me because I want it.
All right, thank you so much. Now it's time to look into this issue in more detail with questions from our members. Here are the guidelines. Only Badger Club members may ask questions of our speaker. You'll recognize them by their name badge. And please note that it is possible to become an instant member if you have cash or check available when we call on you. It's just $60. Questions are limited to 1 minute, less if possible. It should be framed as a question, not as an opinion with a question attached to it. Answers are limited to 2 minutes and will be carefully timed. Please let me reiterate. If you try to give a speech instead of ask a question, we will need to cut you off and move to the next person. Please raise your hand and we'll come to you with a microphone. Please stand, state your name, and ask your question. And since I have the microphone, I will ask the first question. And this is for both of you. So in many ways, this decision brings into focus what happened last year with Arlene's Flowers here in the Tri-Cities, in which a small business owner chose not to provide flowers for a gay wedding because of her religious beliefs. Would both of you discuss the relevancy of that instance with the Supreme Court decision?
Sure. Yeah, I think legally speaking will have very little bearing because the Hobby Lobby decision was again decided on a Religious Freedom Restoration Act, which is federal law and limits what the federal government can do. 18 states have chosen to adopt their own state RFRA. Washington State is not one of them. We do not respect individual rights in the way that many other places do. So that standard would not be available. So I don't think it will be argued on First Amendment grounds and free expression and other grounds. But I don't think that the Hobby Lobby decision, because RFRA was at issue, will have much to do with that case. But the principle of should I be able to force you to do something because I want it is very much at play, just in another legal, just another argument.
So I completely agree that because it was decided under RFRA, federal law that does not apply to states, there should not be legal repercussions for issues such as Arlene's Flower. I would also say that the decision under Hobby Lobby had to do with an employer providing a health plan and what was in this health plan. It wasn't about services that an individual company or organization was going to provide to someone who came in requesting those services. So it's a different issue. Does this mean that though businesses, business owners will feel emboldened to now refuse to provide services to people, to discriminate in the public marketplace? It may.
Okay, I think we have a question over here. Ron, did you have a question?
Yeah, I have.
Right over front.
I'll hold it down to a normal height there. Ron Catherine, very interesting arguments, I take it you're both lawyers, made. But I'm just an ordinary average citizen, and I'm curious about something I have for each of you. Our lady, Leah from the ACLU, argued several times that these folks are being denied health treatment. On the other hand, can't read your name, but Joseph made the statement they were not being denied. What I'm curious about is they certainly were not being denied because they had some health care, and there was no prohibition against them going out and purchasing it. On the other hand, the argument that, well, you have a right to certain things, but I don't have to provide them, would seem to be the exact same thing. I have a right to certain things, you don't have to provide them, but you also are not to forbid me or prevent me or hinder me from acquiring and utilizing that right. So how do you square those two things? That's the long question. You'll have to pardon me, but I'm programmed, I'm a retired teacher, and I'm programmed to speak in 90-minute intervals. So.
Sure. Thank you very much for that question. So when we're talking about a denial of health care or making it more difficult to obtain health care, what we're talking here is about, based on this decision, a for-profit company, closely held corporation that decides to, for religious reasons, not to provide these services or these benefits, now do not have to. So there would be a denial of health care there, because if you're obtaining your health care through this program, you then would have to separately pay to obtain these services elsewhere, and that can, for many people, be a cost barrier, an obstacle that they can't get over. So that's where the denial comes in, or the difficulty in obtaining comes in. And I will now let Joseph, who's going to disagree with me. Go into it.
Yeah. And that all of that presupposes that I have a right to dictate different terms to my employer than the ones I did when I accepted the job. If you need, as a condition of your employment, a drug that you can buy for yourself for $9 a month, if that is a make or break deal for you, you are free to find a different job. Most employers don't object, but if they offer you a compensation package which will include certain health coverage, and they tell you up front, this is what we are going to pay for, this is what we are not going to pay for, if that is unacceptable to you, you are free to not take that job and take one that you want, or you're free to say, you know, I love the job, I want this, I'll go pay for it for myself. That's something that the market, you know, is big enough for. You know, even 20 years ago in America, the idea that I was going to force my boss as in my compensation package to give me something that violates their beliefs, that's not an American idea. That's a novel, totalitarian concept where I get to tell you what to believe and what to do with your money because I want you to and because I think I can. And when it comes to access, I think it's actually true that contraception is actually more accessible than electricity and running water in America. There are very few things that are easier to get than contraception. So the idea that there are millions of women who don't have access to contraception is just factually not true.
Okay, we have a question right here.
Oh, all right. My question, I guess, would...
Your name, please?
Oh, yep, Jennifer Baker. I would direct it to Joseph, and I found your C.S. Lewis quote to be very interesting because you mentioned about the tyranny for the good of victims. Do you not see the irony in Christians being the omnipotent moral busybodies and how this ruling brings us closer to totalitarian government?
I don't see how. The fact that as an employer, they cannot be forced to do things for their employers that their employers would like them to do is the opposite of tyranny. The idea that the government can go into a contract that two people agreed to in advance and now say, now you, party B, must do this for party A, even though both of you agreed to different terms earlier, and bring the state's police powers into that contract. That's what tyranny looks like. The idea that you and I can have a conversation, and I'll say, I'm willing to pay you this to do this job, and you're willing to say, no, I want this, and I'm like, well, that's not acceptable to me. And so we part ways, and we find people that we are, you know, more able to work with. That's what freedom is, where you make your choices, I make my choices. If we can reach agreement, then great. If we can't, you know, we go find other people. The idea that now I'm forced to do something because you want me to, that's tyranny.
And I think the only thing I'd add to that is we have to be careful when we're looking at this and saying it's two individuals making a contract with each other and why should one person force another. This isn't the same thing as someone on the street just talking to you and saying, let's make an agreement. We're talking about an employer. There are certain things, and throughout our laws, there are certain things that employers are required to do for their workers, and these laws change over the time. And just because I happen to be employed before equal pay law came in doesn't mean an employer shouldn't now be required to provide me with equal pay. That's how the law works, and it's to ensure that everyone is protected. With that in mind, absolutely, as Joseph said throughout his talking points, there should be structure and there should be restrictions on this, and the court should look at this. And I personally am a strong support, the ACLU is a strong supporter of the Religious Freedom Restoration Act. We were huge proponents of it when it was enacted because we have to protect religious freedom. But that doesn't mean the court decided this case right. It doesn't mean that employers shouldn't be required to also watch out for the rights of their workers and be required to provide them with necessary health care.
May I respond to that? And again, very, very quickly, and the reason that there's a challenge with that is because if Congress stepped in right now and said, there is now a right to be free from offensive speech in public. We want people to not be offended, and therefore you have a right in your workplace or on the street to be free from offensive speech. That would not make that constitutional, because we would all go to court, and I think the ACLU would be with me, and would say, no, you can't grant somebody a right to be free from offensive speech, because the only way to enforce that is to take away people's First Amendment right to the freedom of speech. And that's exactly what happened in this case. They created a statutory right to force your boss to buy you something that violates their conscience. And what the court says is, no, that exceeds the constitutional authority and it violates our First Amendment, therefore you can't do that. So that's exactly what the court is there to do, is to stop Congress from doing things that infringe on our rights.
And I would say the court absolutely did not say that it violated the First Amendment rights. This court decision was decided under the Religious Freedom Restoration Act. There is a completely different standard under the First Amendment, and the court did not get to that issue. So no, this was not decided on constitutional grounds. And further, from the ACLU's perspective and many others, absolutely you can challenge these things, but we believe the court got it wrong. They did not decide this. They used the compelling interest test, the strict scrutiny test, but they went beyond any previous case law under RFRA or under the First Amendment. They said that a corporation can exercise exercise religion under the Religious Freedom Exercise Act that hadn't previously been determined, that hadn't previously been decided. So this was very different than what's been decided in the past, and it was not decided on constitutional grounds.
And the only alternative to that is that people surrender their First Amendment rights and their constitutional rights as when they start a business and hire employees. That's the only alternative. Either we have the rights as individuals, are businesses owned by people, or are they tools of the federal government?
My name's John Hergert. I'm a pastor at First Lutheran Church in Pasco, and the danger here is having a teacher and a pastor talk because it could go long. So I'll try and do it within the 2 minutes. I guess trying not to make too many comments as well as ask a question. My question would be, I'd say to Joseph, you've tossed around the number of what contraceptive costs. I'd like to know your source for that, because what I understand and what I hear is that cost can go up to $300–400 per month. Those are the sources I'm hearing. And I guess I don't understand why Hobby Lobby needs to get in bed with me. And so can you tell me how that's, I don't want them making those decisions for me and my family.
Well, I'm inclined to agree, which is why Hobby Lobby shouldn't be forced into bed with you to furnish the accessories.
But they're not a person, they're a corporation.
What was the first question?
Where'd you get the 9 o'clock, you know?
Yeah,
and
that was somewhat tongue-in-cheek. There's a range of contraceptives. Some of them cost $9 a month. Some of them cost more than that. No. So I'll grant that point.
I would also like to add, I mean, I hadn't heard that women had more access to contraception than electricity and water, and I would be interested in finding out those points. But also, some of the 4 contraceptives that were at issue in this case included emergency contraceptives and IUDs. IUDs are some of the most effective types of contraception, are also some of the most expensive. As Justice Ginsburg said in her dissent, there are many studies that have been done, and they are sourced in the dissent, and you can look at them, that show that women want to obtain IUDs to make sure that they do not get pregnant, their families do not start families before they're ready, but do not obtain it because they're so expensive, and they can cost up to or over $50 a month. Thank you.
Ed Frost, I've got a question for you, for both of you. Business law has always recognized a curtain between business owners of small businesses and for-profit businesses and the assets of those owners and the business. There's always been a curtain between those two. There are some legal scholars now who believe there is a tear in that curtain caused by this Supreme Court decision, that suddenly the religious beliefs of the owners flow through that curtain to affect the employees of their company. There are now legal teams working with small business that are very concerned that that rip in the curtain will actually be a vehicle for people who have a financial claim against that business, either because they're creditors or because they're suing, to actually access the assets of the individuals who own the company. And it's based on this perceived tear in the curtain. Since you're both attorneys, I would love your comments and thoughts on that idea.
Thank you for asking that question, because I have been, ever since I read this decision and I read the oral arguments leading up to it, I have been extremely confused, because one of the key purposes of forming a corporation is to separate the individual from the corporation, to escape certain forms of liability, so that as a shareholder, when someone sues your company, your individual assets, your family's money and house aren't necessarily at risk. It is therefore confusing that while forming a corporation should separate you from the entity, it does not separate your boss's religious beliefs from the entity. And I think the idea you're getting at is a concept in law we call piercing the corporate veil. And while normally the individual is protected by forming a corporation, when you pierce the corporate veil, you can then get at that individual. And it's normally because of issues of fraud, and this is where I think it comes into play, where the corporation is acting as the alter ego for the shareholders, for the owners. And I think what the concern has been is that if you have your boss's religion running the company, does that mean that the company is acting as an alter ego, which would cause piercing of the corporate veil? I would assume that the courts are going to find a way around this, because this is not a solution they're going to want. I think there will have to be some legal maneuvering around it, but I think it raises a lot of questions and is very confusing, and is something I've wondered about continuously ever since the decision came out.
Yeah, there's a helpful analogy here, I think, because there's been some other court cases that have found that non-discrimination laws apply to businesses that are minority owned. And the same question is, can a business be black for the purpose of non-discrimination law? Can a company come and say, hey, we have been denied all these contracts because of the race of the owners of the company? And the courts have said, yes, that a company can be discriminated against because of the characteristics of its owner. And so in the same way that a company can be black for the purpose of non-discrimination laws, the courts have simply said that you cannot, in every situation, pretend that companies are soulless and identityless, because there are real people involved, and because there are real people involved, there are real impacts. And what that means is that companies can be discriminated against because of the race of the company's owners, and in the same way, those individuals also have beliefs, and those beliefs are protected by the law and should continue to be protected by the law.
And this might be a legal nuanced issue that we should debate out afterwards, but the one thing I'd want to point out is there a significant difference if someone is discriminating and refusing to, let's say, work with a company because the owners are black. They're discriminating because the owners are black. That is actually discrimination against the individual, and the company is feeling the ramifications of it, but there is a direct connection to the individual there. The discrimination is based on the individual, and that might be a legal nuanced issue that we should go into after.
And certainly the owners of these companies, the Green family, would say there's a connection to the individual when you were saying, I personally have to pay for these things that violate my belief. I see no distinction, but yeah, you're right.
We'll
we should
talk about it after.
Talk about it later.
John Swope. I would like to ask you to address the asymmetry of this situation, which has been kind of talked about, but it seems to me that the government often does step into relationships between individuals and corporations that employ them and insist on certain things. And I understand that you're trying to make a distinction that this is not acceptable here because of the religious convictions of the owners, but I'm not sure that convictions of the owners allow the corporation to avoid compliance with the law, and why there's the implication that a corporation could have a religious orientation as opposed to the individual owners practicing their religion.
Well, I think you've restated the question well. I think that's exactly what it is do you, as an individual, if you start a company and hire people, does that mean you surrender the otherwise constitutionally protected rights that you have to make decisions that are consistent with your conscience? I think that is the question. And my position is that no, you should not. And that America should be big enough to allow individuals who start companies to allow those companies to be an expression of the dreams, the vision, the values, and the beliefs of the people who started it? Or, once you become an employer, do you surrender those rights, become an extension of the federal government, and now all you are is a tool for the government to provide things to people that they think are important? I think that is the fundamental question, and I think there's 340 million people in this country. There's lots of companies, there's lots of individuals. If you need contraception, there's somebody who's willing to pay for it and provide it for you. And we don't need to get into the situation where the government now views employers as extensions of themselves and disregards the otherwise constitutionally protected rights that they have.
And just briefly, and I know I mentioned this before, and I don't mean to harp on it, this wasn't a First Amendment issue. Joseph was again claiming it was, and it is not. This was based under federal law, and that's what's decided about. It wasn't people's First Amendment rights. That just wasn't what was going on here. And secondly, I want to say I really don't want to underplay the difficulty it can cause a woman who does not have the economic means to obtain contraception to obtain access to it. It is not always super easy. It is not super simple, especially if you have a health plan through an employer. So that is how you normally obtain your contraceptive services, and they are not willing to provide it. So I just don't want to minimize that.
And if the government wants them to have it, they can pay for it.
And the one thing I'd want to say to that is, where does that end? Going back to the equal pay, would the answer to the question then be, well, I don't want to pay women equal amounts because they are not the heads of households under religious beliefs, therefore the government should pick up the slack? I just think that's a really scary, slippery slope to go down.
All right, I'd like to welcome our newest member. Michelle Andrus would like to ask a question.
You get to ask a question.
Okay. Yes, I stepped up with my wallet. But this is a very nice forum to be a part of, and so thank you. And I'm probably going to fumble my first question, but I used to sell health insurance. I was an agent, and I understand that every insurance company in Washington State provides a policy with an option for women to have access if they want that. The employer provides the opportunity. They don't necessarily they have the option to, let's just say Blue Cross Blue Shield, and they have multiple policies where a person can choose. But the employer doesn't have to pay for their choice. What I think is fair, and I wish, and I'm sorry fumbling this, but I think that if an employer offers insurance and there's two different policies, they allow the individual to make their choice. But they don't have to support the choice that we've now been told that did not go through the legislature this year with the abortion mandate, was that every single policy that offered maternity care had to offer the abortion coverage. I don't believe that that's a fair choice for the employer and the employee relationship. I think the individual should have the right to choose, but I think the employer can offer the policies that they have, and I would like you two to address that.
So that is a very interesting point that actually in an amicus brief the ACLU submitted got to this issue, as did Justice Ginsburg dissent. And the issue that becomes, what is to attenuate it? Because in these situations, and I didn't catch your name, but like she was mentioning, what you really have is not the employer directly providing contraception services. They're giving money to a general fund, and then it's the individual's choice whether or not they decide to obtain contraception. So it is not the employer directly paying for your contraceptive services or deciding that they need to or do not need to. It is the individual who's making those decisions, and I do think that is an important distinction to make.
And essentially what she's arguing there then is if an employer objects because this is, I believe this is in violation of my beliefs, that the government should step in and say, no, it's really not, because you're not really paying for it. In which case, we now have the government dictating to the individual what violates their beliefs and what does not. And that's the principle that is the problem here, is do we as individuals get to determine for ourselves what we're uncomfortable with, or does the government get to create a list of things that you're allowed to be uncomfortable with?
And I think the distinction I'd make there is there a difference between saying, is a belief sincerely held? And I firmly believe, and I think everyone in the court believe, that Hobby Lobby and other people making these arguments, their beliefs are sincerely held and we should respect those beliefs. That is different than saying, is this a substantial burden upon you? If you are just putting money into this pot and then other people are making these decisions, from a legal perspective, because as Joseph correctly stated, one of the questions is substantial burden. Is this a substantial burden? And that's where I think there's a legal distinction that has to be made here, which has to do with whether something attenuated. In no way do I want to suggest that this isn't a sincere religious belief and that we shouldn't respect it, because absolutely we should.
Which is another way of saying you shouldn't care that much. And so we're going to make you do it anyway.
I don't think that's what I was saying, but okay, no. Thank you.
if the government gets to step in and say, no, I realize that you care and you're willing to shut down all your businesses if we tell you to do this, but you really shouldn't feel that way, therefore we're going to make you do it anyway.
All right, we got time for one last question.
Brett Menaker. I guess my question is primarily for Joseph. If as a business owner, I can be legally exempted from providing a benefit to my employees that would otherwise be required based on my religious belief, the exemption based on my religious belief, why could I not be exempted for some non-religious reason? Maybe I just don't want to.
Well, you could. I mean, that's the whole point of this. Is it's not just and we say religious belief probably too specifically, because conscience rights extend beyond people who believes things for religious purposes. And what we are advocating for is the right that the individual gets to draw those boundaries for themselves, and whatever it is that inspires them or motivates them or convicts them, that they are the ones that determine that. And so as to, again, the question, is this a bridge too far? Are we creating a precedent? We have a Bill of Rights, we have a Constitution, and we have a recognition of the rights that individuals have. And in this case, the Supreme Court recognized that our protections for religious freedom, as recognized in RFRA, do not allow the government to tell people that they can do this, specifically because there's an easier way to provide this without forcing people to violate their beliefs.
And the one thing I'd add to that, I'm sorry to harp on this did not have to do with the Bill of Rights. This did not have to do with the Constitution. It was under RFRA. Therefore, it was not the religious rights that are granted religious freedom under the Constitution. It's an important point to make. Also, what I'd say is I think that's a really great question, because where does this end? And I just think it's a great thing to think about. We really don't know right now.
Freedom has, as a result of being free, the price that you pay for not being able to be someone's slave is that you cannot make someone else your slave. That is true. We live in a world of trade-offs where you can't have everything that you want. But because you can't force other people to do things they don't want to do, you also have the right not to be forced to do things that other people want you to do that you don't want to do. That's called freedom.
Okay, thank you. We will now give our speakers 2 minutes each to wrap up their presentations with final thoughts. Let me ask our Digger Award Committee to start caucusing now so we can present the Digger Award for today's best question. And I think we started with Leah earlier, so Joseph, why don't we start with you this time? 2 minutes, please.
Again, thank you for being part of this, and I have enjoyed it, and I hope you guys have as well. To rephrase what I think the question here is we have a well-established legal standard for what the federal government is able to do when they can and cannot infringe on people's fundamental rights. And I think that the strict scrutiny standard, as the Sherbert test from 1962 established, and as was reestablished in RFRA, is one that works well, because it recognizes that conscience rights or religious freedom, however you view that, whatever your perspective is, that those are inalienable rights endowed upon us by our Creator, that served as the foundation of what this country has became as the freest place in the history of humanity. And that wasn't an accident. It was because we respected the dignity of every individual, and we said that the government does not have the right to tell you as individuals what you want to do just because they want to. What is being proposed as an alternative is a test of good intentions. That as long as I mean well, as long as I'm trying to solve the problem of access to something for people who may not be able to afford something, because of that, therefore, I can make anyone do anything I want to do. And we've seen that work so badly in our country's history. Again, those were the justifications for why we had internment camps. The proponents of segregation argued for the same thing. The proponents of book banners, the proponents of all sorts of censorship believed they were acting on behalf of the public good. What we need to recognize, and what I think the Hobby Lobby case reinforces, is yes, there are trade-offs. But worse than the fact that guilty people should go free is the idea that an innocent person should be convicted. And worse than the fact that people would be offended, worse than that is the idea that government would control people's speech. This is why we don't do that. And I would say, in this case, it's not worse that someone should have to pay for their own contraception than we all maintain the autonomy to make decisions for ourselves.
Thank you. I would respectfully disagree that this is a debate about whether we're dealing with a strict scrutiny test or a test of good intentions. The ACLU strongly supports the strict scrutiny test. As I said, we were huge advocates of the Religious Freedom Restoration Act when it was first brought in after 1993. I think it's great that there are strong protections for religious freedom. I just think in this instance, the court got it wrong. They went above and beyond the normal test that is applied in strict scrutiny under the Religious Freedom Act. That is what we're debating, whether the court got this right or got this wrong, and I think they got it wrong under this particular test. This in no way means that we shouldn't make sure that religious freedom is protected and it has strong protections under it. At the same time, I think we have to protect everyone in this room, both for their religious beliefs and otherwise, and just because one individual who happens to be your boss, who happens to have that relationship with you, has certain beliefs, does not mean you shouldn't have access to health care or have any other of your rights or needs denied to you. Thank you very much.
Thank you.
Back home, the Executive Director of the Family Policy Institute of Washington. And today we're going to talk about the Hobby Lobby decision and why it's good for those of us who care about freedom and individual rights and really preserves that for all of us.
Our perspective that Hobby Lobby essentially was the highest court in the country ruling that an employer's religious beliefs can discriminate against their employees, and how that will impact not just women and their families, but all of society.